And good morning, Your Honor.
Yeah, and I've sent him the Zoom information twice now, so I don't know what's going on.
So, Mr. Graff, are you in Vegas or are you just enticing us there?
I'm just enticing, Your Honor. I have a amateur photographer's habit, and since the advent of Zoom Court, I've used it as an opportunity to just post some of my work up. So,
Cool.
little vanity project, Your Honor.
All right. Wish we could all be there. That'd be fun.
I agree. Thank you.
I went recently and it was too expensive though. So I'll just look
Oh. They're too expensive or too hot whenever I've been there.
Yeah. Okay. So Rachel, can you call the attorney's office if you have that number?
Yes, I'll try him right now.
Thank you.
Okay, Judge, it appears we have everyone here for this one now.
Oh, good. Okay. Good morning, everyone. I think, and is that the mother with Mr. Harwood?
Yes, ma'am, it is.
Thank you very much. All right, then let's go on the record in cause number 9/2024. And if I could have announcements, please.
Good morning, Your Honor. Eugene Graff and Cherie Hughes on behalf of the department, present and ready to proceed.
Thank you.
George Harwood, attorney for Alina Sanchez. She and I are both present. We're ready to proceed.
Thank you.
Stacy Zabala on behalf of the children.
Thank you very much. Mr. Graff.
Thank you, Your Honor. And I know that typically on compliance hearings, we just do an update with the social worker. So that's how we would prepare to proceed this morning. I know Ms. Hughes did file a court report. So if I can ask her to just update the court as to mother's compliance and progress, as well as the department's recommendations for this morning.
That would be fine. Ms. Hughes, let me get you to raise your right hand and unmute. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you very much. You may proceed, Mr. Graff.
Thank you, Your Honor. Good morning, Ms. Hughes. Are you the assigned FBSS specialist in the Sanchez Garcia matter?
Yes, sir.
Okay. And did you file a compliance hearing report for today's hearing?
Yes, sir.
Okay. And if you could just report to the court the mother's compliance with her individual services, and then let the court know what your recommendation is for this morning.
Okay, so Mrs. Sanchez has done really well with me. I never had a problem meeting with her. She's returned all phone calls, text messages. There's been great communication with her. She has completed all of her counseling. And I did speak with her yesterday. We kind of had some confusion with her rational behavior therapy class, but I haven't received a notification that it was completed, but I did talk to her yesterday and she completed that on October the 10th. I do not doubt that she didn't complete that. I just don't have notification yet that from Troy Timmons that was completed, but I'm sure that she did. She also has drug screened when I've asked. I've had a dilute negative and then a negative. And on the OSAR, we had a really hard time getting them to call her. Finally, that did happen. She followed through with them and she did a assessment with them. They did recommend Padre. And then Mrs. Sanchez and I did discuss kind of what happened there. She refused their recommendation. It was her understanding from the previous court hearing that I was not a part of that maybe that part was dismissed out or was not agreed upon for her to complete that. It was her understanding that it might be inpatient or outpatient treatment. I've gone back through everything that was given to me that was filed with the courts. I don't see that anywhere. I do understand what she's saying when the terms are inpatient or outpatient treatment when Padre is actually just drug education. And I did explain that to her. So I know that's the one and only thing that has not been completed. And I thought maybe that was something that we could discuss today because I understand her what she's saying, that it's not that in the wording of the court, it's inpatient or outpatient treatment where Padre is a little bit different, but that was their recommendation.
Okay, so their recommendation was just education. And I'll just note for the record, as of on the July 30th order, it says submit to and cooperate fully in the preparation of the court order drug and alcohol dependency assessment and follow all recommendations for inpatient or outpatient treatment services. So I see that there's a little, I think we can get that clarified with the court this morning. But as far as drug education, that would be, I guess, a form of lowest level intervention in the form of an outpatient relapse prevention type program. Is that
That's
your
my
understanding?
That's my understanding, yes, sir.
Okay. All right. But other than that, it sounds like she's fully compliant and has progressed with all other services and has worked with you in good faith.
She's done very well. She provides for those girls really well. She recently moved. I've already seen that home. It's very appropriate.
Okay. And then, but for this lingering question on the treatment recommendation, what is your recommendation for the case this morning?
I mean, I personally think anyone would benefit from drug education. However, I know the Padre classes, that program is really long. I know that she was personally wanting this to be kind of a shorter type. I'm trying to think. I know this was put on her by the court, and I know that she was wanting to get the court order dismissed out. I don't think that's because she doesn't want to work with the department, but I know that Padre it's a really long program, and so I'm not sure where we want to stand for that, because I believe that could be another 2 to 3 months before that would be completed.
Mm-hmm. Okay. I'll ask you one last question before passing you, and I'm probably going to steal a little bit of Mr. Harwood's thunder with this question, but have you seen evidence of any substance abuse during your interactions of the mother or with the mother, other than the dilute sample?
Absolutely not.
Okay. Thank you. Pass the witness.
Thank you, Mr. Harwood.
Ms. Hughes, do you have something in writing from OSAR? I never have received or seen anything in writing regarding their recommendations. Perhaps it just didn't get sent to me, but I've not seen anything.
I received an email, and it was written very, very teeny tiny. It's kind of hard for me to read, but I can definitely pass that on to you. I'm not sure if Mrs. Sanchez received a copy or not.
Okay. And she completed all services and complied fully with you, except for this question mark about whether or not she needs to participate in the Padre program.
Yes, sir.
And you don't have any doubts or reservations at all here today about her being a substance abuser?
Not at this time, no, sir.
And would you agree that we're here mainly, or got here mainly, because of one drug test done back in the summer on which she tested positive, and she's tested negative ever since that one test?
Yes, sir.
I'll pass the witness.
Mrs. Lala.
Ms. Hughes, in addition to the drug issue, there was some family violence type issues. Do you feel like those have been addressed in this case?
I do. Talking with her and just being in the home and being observant of what is there or what is not there. I have not seen any signs of the man that was involved at the first part of the case. And she has stated to me several times that they are no longer in a relationship.
But if he was around, that would be a continuing concern, but you're not seeing anything that makes you think that.
Correct. Yes, ma'am.
Okay, I pass the witness.
Back to you, Mr. Graff. Any further questions?
Nothing further. We rest, Your Honor.
If I could just ask Ms. Hughes one question, Your Honor.
Sure.
How many sessions did Ms. Sanchez have with Dolores Henders, the counselor that the state wanted her to see?
The state actually asked her to do 6, and I believe she did 1 extra.
So she did 7 sessions with Ms. Henders
If I remember correct, yes, sir.
for 1 hour each.
Yes, sir.
And that was to address any issues that might be there, including family violence, drug use, or anything else that Ms. Henders developed in the course of that counseling.
Yes, sir.
And so do you believe that probably those issues were, or do you receive any kind of report from Ms. Henders?
I do not. I just talk to her on the phone. She doesn't send me anything.
Well, did she indicate that she had any reservations or concerns about Ms. Sanchez at this particular point?
No, sir.
Pass the witness.
Mrs. Zavala, anything further?
Nothing further, Your Honor.
Thank you. I believe Mr. Graff has passed, and so Mr. Harwood, do you have any witnesses?
No, Your Honor, I have Ms. Sanchez here. I think she could just testify to what she's done. And, well, let me call her briefly. I think the court needs to understand why we want this over with, and she can address that with the court.
Okay, ma'am, if you'd raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Tell us your name, please.
Alina Sanchez.
And you've been present and heard the testimony of Ms. Hughes concerning your compliance with the department on these issues.
Yes, sir.
And the only thing that you are in disagreement with is this continuing drug education with the Padre program.
Yes, sir.
And you don't want to do that because it's a long program, as Ms. Hughes has said. Is that correct?
Yes, sir.
Are you in litigation with the father of another of your children, Kinsley?
Yes, sir.
And is that a reason that you would like for this to come to an end so you can focus your attention on that litigation and not have to deal with this and the possibility of them using this against you in that litigation?
Yes, sir.
Is there anything else that you want to tell the court here this morning regarding your not wanting to do the Padre program?
No, sir.
Okay, pass the witness.
Mr. Graff,
No questions, Your Honor.
Ms. Zavala,
No questions.
thank you. Any other witnesses, Mr. Harwood?
Oh, Your Honor, we rest.
Thank you. Ms. Zavala, do you have any witnesses?
I have no witnesses, just a quick report.
Okay, please, that would go forward.
Your Honor, I got to meet with Ms. Sanchez and the children in the home. She was very cooperative with me. The home seemed appropriate. Now, I think maybe this was prior to the move, but if Ms. Hughes has seen the new house, I assume that that's appropriate as well. She has been cooperative with me and allowed me access to the kids.
Do you have a recommendation, especially in your guardian ad litem role, as to the request that's being made by the mother as to the drug education?
Your Honor, I was very concerned with the allegations in the complaint. I think there were some serious issues that needed to be addressed. It does appear that Ms. Sanchez has stepped up and done what she needed to and has been cooperative with everyone. Ms. Hughes is in the home at least weekly, I believe. And I rely on her judgment in thinking that those issues have been addressed. I had some big concerns about the family violence issues. I don't think those were small issues. I think that's a big deal. But it sounds like she has made the correct changes for that. I do hope that Ms. Sanchez continues on the sobriety path. Generally, we like to see a little bit longer in terms of sobriety. But at this time, if Ms. Hughes is okay dismissing this case, then I would not object to that.
Thank you. Ms. Hughes, you've heard the recommendation of Ms. Zavala. Do you still wish to, do you still believe that going ahead and dismissing this would be appropriate?
I do.
Okay. Anybody want to argue the other way? Or I think y'all got enough cases. You got a mama that did what she's supposed to. So what a joy.
Yes, ma'am.
Tell me, once you mark that one down, Ms. Hughes, for a 1.
Yes, ma'am.
So Ms. Sanchez, I'm gonna do you a good one. I'm just the visiting judge, so what the heck? It sounds to me like you've done everything you're supposed to do. You understand that if you fall, this is not going to be good, especially if you come back in front of Judge Baker and I let you go. So I'm gonna dismiss this with the knowledge that you're not going to see all these people ever again. Correct?
Yes, ma'am.
Okay, well, we wish you good luck in your other venture, and I don't see any reason to prolong this. It appears to me that Ms. Sanchez had a slip up and has corrected all of those issues. So with that, I will dismiss this case.
Thank you, Your Honor.
Judge.
Thank y'all. Have a good morning.
You too.
Thank you.
Your Honor, in terms of the next case, I had a conflict, so there was a different ad litem that was appointed. I'm just gonna turn my screen off and not participate because I'll be in the rest of them that follow.
You're gonna let Joel Jackson sit in for you? Really?
Yeah.
I know Joel from 20 years ago. This is gonna be fun. Is that Joel Jackson with all that gray hair up there in the corner?
It couldn't possibly be. He is so young and with it. It couldn't be.
Really?
Here's the thing, Judge. You can dye hair. I mean, I have no options unless I put shoe polish on my head.
Judge, I just waiting on you to chime in. Good to see you.
It's good to see you. Joel and I go way back to little baby attorney generals a million years ago. So.
They swore to us when we became lawyers, all this gray hair would be distinguished, Your Honor. I'm not finding it to be the case.
You know, Vince, they do make a spray on you can use.
Yeah,
I
no,
need to do that,
no.
Tippy.
Listen, Tippy, it's called Topics and it's a sprinkle. And I kid you not, back when I was vain, I used that. And then one day Steve Ford said, Vince, just embrace your baldness.
I have a friend that calls that your upper face. So you're
There you
good.
go.
All right. Okay. Okay. We're straight face here. All right. Let's go on the record and cause number 9. This is a compliance hearing. Today's date is October the 15th, 2024. And if I could have announcements, please.
Thank you, Judge. Good morning. Gene Graff and Katrina Sledge on behalf of the department, present, ready to proceed.
Thank you.
Stacy Grant on behalf of the mother, Melissa Sanders Hudson, and she is in, Your Honor.
Vince Nowak on behalf of
A permanency review before final order inside of an extension. Or if I could have announcements.
Daniel Trout for the Texas Department of Family and Protective Services. Erica Cantrell is my permanency specialist. We're present ready.
Thank you.
Savannah Kincaid, I represent Miss Tenor. We're present and ready.
Thank you. Mr. Jackson, you're on mute.
Yes, ma'am. Miss Lewis just informed me of that. Bill Jackson, on behalf of Tyrone Lewis, the father, present and ready, Your Honor.
Thank you.
Stacy Zavala on behalf of the children.
Thank you. Mr. Trout.
Thank you, Your Honor. Erica Cantrell will be my witness today, Your Honor.
Okay, Ms. Cantrell, if I get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Let me tell. I was on mute. Yes, yes, and I do.
Thank you very much.
I'm like, how do I unmute it with my hand up?
The other hand, okay? All right,
you.
you may proceed. Thanks.
Ms. Cantrell, state your name and your position, please.
Erica Cantrell, I'm the lead permanency specialist with St. Francis Ministries.
And you're currently the worker on, or the permanency specialist on the Lewis case. Is that correct?
Yes, sir.
Okay. Outside of the court report, how are things going? Is there anything new that the court needs to be updated on?
No, everything's going well. We've been doing our weekly Saturday checks, just to ensure that there is that supervision there on Saturdays. I just discussed with my supervisor or my director, excuse me, and we're going to go back down to just once a month, Randall, to go do that because they've been complying and they're doing what we've asked. Parents, dad's drug screen was negative, his last drug screen. So things are going, they're going well.
Okay. The children still doing well?
Yes, they're doing great.
Okay. And I know this will probably come up, and I know you and I emailed on it yesterday. There's some discovery that's outstanding that is currently in y'all's possession now.
Yes, we received that late last week. So I will have it brought to your office today.
Okay. And to inform Mr. Jackson, Mr. Kincaid, I will have that ready for them to pick up probably within the next day or so. Anything else that needs to be updated or that we need to discuss?
No, I think the only thing today is just getting the drug screen for the parents court ordered for October and just continue as we are.
All right. And when was the last drug screen? It was in first part
September, our last hair was August. Parents did those in August. So, I mean, UA's today would
Okay.
be sufficient.
All right. I see the last one in the court report was August 30th. Did they do a drug screen in September?
The dad did. Mom started work, and so I was not able to get her in, and that is on me. But she had started work again after her maternity leave, and it interfered with her schedule at the time that I could have sent her.
Okay. So today you're asking for a UA on both parents by 4 p.m. today?
Yes, please.
Anything else?
No, that's it.
Okay. I'll pass the witness, Your Honor, with the only request that we have order the parents to drug screen by 4 p.m. today on the UA.
Thank you. Ms. Kincaid, any questions?
Thank you, Your Honor. Visits are going well, is that correct?
Yes, ma'am. We have had some, Andrea, who supervised, has had some family emergencies and such. So a couple of Fridays we weren't able to do, but we just added those 2 hours to what they're doing on Saturday. So they're getting all their visitation during that time.
Okay. And are there any services left for Miss Tenor to work?
All services have been completed.
Okay, so the only thing we're waiting on is the discovery, is that correct?
The discovery, and then I believe the hearing regarding the expert testimony.
Okay, thank you. I'll pass the witness.
Thank you. Mr. Jackson, any questions?
Thank you. Ms. Cantrell, you said that all services have been completed. When you made that statement, are you referring to both parents?
Yes, sir.
And have the parents been compliant with the department?
Yes, they've been compliant with me. We have good, positive conversations. They're respectful. They understand our position. So there's definitely a good working relationship with the parents.
Okay, thank you. And just for the court to be in the know, on July the 26th of this year, the Lewises had another child, correct?
Yes, that is correct.
And that child is currently placed in the home with them. Is that correct?
Yes, sir, it is.
Okay. I have no further questions, Your Honor.
Thank you. Ms. Zavala.
Your Honor, I have no questions of this witness. I don't know if Mr. Jackson and Ms. Kincaid are going to call their clients, but I do have a short report whenever it's time for that.
Thank you. Ms. Kincaid, do you have any witnesses?
No, Your Honor, no witnesses.
Thank you. Mr. Jackson, any witnesses?
No, ma'am.
Okay. Ms. Zavala, your report then.
Your Honor, I was able to go and observe another visit with parents and the kids. It went very, very well. Parents are very good at redirecting the boys and keeping them entertained. It really seemed to manage them quite well. That's in line with everything that I've seen and heard throughout the case. I do understand that this is a scary case, but the parents have worked their services. They've been very cooperative with me. Foster parents also give very good reports about their interactions with parents. So I just wanted to let the court know that.
Thank you. Obviously, I just sort of breezed through this. So are there some hearings set for, it sounds like, for some expert testimony or something?
There has been, Your Honor. We had one and then we reset to allow parents' attorneys to find an expert and to get some discovery done. We were waiting on redacted case files and stuff, but that is what has been received, and I should have that in my office today and can get it to parents' attorneys. And then we will get a hearing set. We'll reach out and get a hearing set once we get all that taken care of.
All right, great. So that's something that's in the works. Because what I have right now is a bench trial set for January the 7th at 9, but y'all are going to be setting hearings prior to that.
We'll probably have a hearing prior to that. Yes, ma'am.
Okay. And I have a drop dead of January the 17th. So you guys are in warp speed.
Yeah.
Right?
Yes, ma'am.
Okay. All right. Then I will find that the parents have been working their services. Apparently, all the parties agree at this time that discovery needs to be finished and the expert witnesses need to complete their testimony. So for that reason, I will find that this case does need to continue basically by agreement of just procedural issues. I do believe that reasonable efforts are being made. Visitations are going well and have been increased. And so at this time, I will give the parents their statutory warnings. You've worked your services. Please continue to work those services. The court is ordering you today to go have what's called a urinalysis exam by 4 o'clock today, if that's at all possible. If not, please work that out for tomorrow if there's a work situation with your caseworker. But I do have to warn you that if you fall off that wagon in whatever form, that your rights could still be restricted or terminated. That's not a threat. It's just the law. I'm required to tell you that. Does anybody else have anything today?
Nothing further from us, Your Honor.
Okay. I guess I need to say reasonable efforts are being made and everybody agrees that it's all in process. So thank you very much and good luck. We'll go off the record.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Judge, before the hearing, could I ask you to place yourself and Mr. Trout into a breakout room and myself?
With me?
Yes, ma'am.
Okay. Yeah, sure. If I could get Rachel to do that, I have no control. I'm just a visitor.
Yes, I'll get that set up.
Thank you.
And Joel, you said the judge and just Daniel?
And that was
Me and the judge.
part of the agreement, as
Okay.
Mr. Noack stated, that we had at mediation. Is that correct?
Yes, sir.
And also a part of that agreement is that agreed to an extension to allow dad to complete some other services and rehab.
Yes.
Okay. That had been pre-approved by the court prior to this hearing today, correct?
Yes.
What else does dad need to do? Is he going to be able to work any other services while he's in Cineor, or is he focusing strictly on that right now?
He's focusing on Cineor. We did ask for Padre.
Okay.
There was one other thing. I'm so sorry.
Good.
For him to complete, and he agreed to everything required of him. Dad's done good and bad, on and off. He hasn't maintained sobriety, but he does engage in the services required.
Okay. And dad knows and admits he has an issue. He was trying to work through that addiction.
Yes.
Okay. Children are with grandfather?
Yes.
How are the children doing?
They are doing really well. There was an incident where Cope was not feeling well to his tummy, and he woke up Grandpa. Grandpa made him some breakfast, and Cope stated he was fine after that. And he had a headache, but he was fine. He didn't go to the doctor. And Crew is growing beautifully. I've gotten to witness them in daycare and in the home, both where they appear to be well adjusted.
Okay. And how is mom doing?
Mom's been engaged in the Virtue Center and IOP. However, she continues to test positive for fentanyl, and she's admitted to still using and struggling with that with her surgeries.
How long has mom been in the IOP?
She has been in the IOP since February of this year.
Okay. Is the department wanting mom to go, ask the court to court order mom to go to inpatient rehab?
Yes.
Is that due to mom's use throughout this case and being in the IOP and does not seem to be working?
Correct.
Okay. Your conversations with mom, has she been willing to go when asked?
No.
Okay. And has she stated why she's not willing?
Yes.
Okay. What are those reasons?
Due to her now new job that she started September and the fear of losing her apartment.
Okay. Has mom, you said that she's admitted to ongoing use. What has mom told you what she's been using?
Fentanyl.
Okay. So we have a fentanyl problem with a mom that's in IOP and it is not seem to be working.
Correct.
Okay. Any other services at this time that you need mom to complete?
Honestly, it would be inpatient rehab at this point to try to help her gain some sobriety for long term for her children.
Okay. Is there any way that goals will change as far as mom if she does not get sober?
I would have to staff with my superiors for direction at that point.
And I understand that, I know it was not a very well-phrased question. Do you still have concern with mom as long as she's still admitting to using fentanyl?
Yes, and her testing positive.
Is there any way that you could consider, or the department would even consider placing the children back with mom or working with mom for placement if she's still admitting to using fentanyl?
No.
Okay. So it is your request again that the court order mom to inpatient rehab to try to get through this sobriety issue.
Yes.
Okay. Has mom worked her other services?
She's participated in parenting and she did complete RBT. She's in counseling with Coleman Lemons. She admitted to speaking to them about her relapsing regarding the struggle she's had with her surgery. And so that's pretty much what she's done. She participates in visitation. I did get informed that she struggles meeting those virtual visits at times due to her workload.
Okay. Where is mom working?
It's a medical facility that I place in Norman, Oklahoma.
Okay. All right. Anything else you need to update the court on at this time?
I don't believe so.
Okay. So again, our main concern and the main request today is the inpatient rehab for mom.
Yes.
Dad's admitted he has an issue. Dad is working with us and has gone back to rehab again to try to get through this. We just need to see the same from mom.
Yes.
I'll pass the witness, Your Honor.
Thank you, Ms. Grant.
Ms. Lane, have the approvals for drug test payments been being sent to a different lab than is called out in the family service plan for Ms. Kirkpatrick?
Yeah, they've been sent to several different ones to try to accommodate Miss Lorna.
Okay. Well, actually, some of them were sent to a different lab to accommodate the department's paperwork, correct?
No, ma'am.
Wasn't there an issue with the lab that's called out in the service plan where you weren't able to reach a live person there when you needed assistance with filing the payment forms?
Can you reword that question?
Yes. Was there an issue with one of the labs as far as being able to do the payments?
No.
Was there an issue with being able to call and get a live person to speak to there?
Yes.
And how did that affect your ability to send drug testing to that?
The drug testing was able to be sent. It was verifying that your client went and getting a report back for it.
Have you
You're
since
muted.
been able to use the lab again that is called out in the service plan and get that fixed?
Yes, she went last Thursday.
And that was the 11th, correct? Have you received those results yet?
No, ma'am, we have not.
And what test request?
Judge, Ms. Grant kind of broke up there. I didn't hear what the last thing she asked.
I apologize. Did you request hair follicle and UA?
Yes, ma'am.
Okay. And in order to do inpatient treatment, we would like to see another OSAR, correct?
Yes, ma'am.
However, OSARs are not what Oklahoma uses, correct? They use the IOP process.
Yes, ma'am.
So is there another assessment you'd like her to do within the IOP that would be comparable to an OSAR before we court order her to inpatient so that we know she needs it?
At this point, she's participating in IOP. We were informed that she bleached her hair for this test and stopped using fentanyl 2 days prior to the testing date.
Objection to that, judge, is hearsay unless she has direct knowledge.
Sustained.
So Mickey, let me ask you a different question because is there a way that Lorna could do an OSAR so that we're dealing with the Texas process and the Texas assessment, which you have to need to travel here? How could we do that?
She would have to travel to Texas, but she could also, she's used her private insurance for quite a bit. She can use her private insurance to go to inpatient rehab as well. We could also attempt to try to pay for it herself. She could also reach out to her current providers, informing them that she needs to go to inpatient at this point.
Okay, so because she's in Oklahoma, she could go ahead and try to process further rehabilitation services through her private insurance. And as long as she communicated that to you, you'd be willing to see if that's acceptable?
Yes.
And I would ask you, I'm sorry, I have a grandbaby. I'm sorry for the screaming, you guys. So would it be reasonable to, did you get the release that was sent to you that she signed yesterday?
Yes, I just got it this morning.
Okay, and so was that the release that you needed that we talked about last time that you were waiting for?
I'm double checking. Yes.
Perfect. So that will allow you to retrieve the records that you need to retrieve to be better informed about what she's doing in Oklahoma, correct?
Correct.
And is there any other paperwork she owes you at this point other than her therapy notes from Mr. Coleman?
No, ma'am.
And I'll represent to you that I have received an email from Mr. Coleman, and I believe we have access to his notes at this point. And so I will be sharing those with you as I can today, if that would be acceptable.
Yes, ma'am.
Okay. So the release and getting in contact with her therapist, those are two big items that you really needed, correct?
Yes.
So would you consider her providing those and getting started on that a step forward for her?
Honestly, with her still testing positive for fentanyl and her long-term abuse, she's going to need as much support as possible. And that's why inpatient for her would be so important for her to maintain that sobriety long-term for her and her children.
And I understand. And so it might be faster through her private insurance. Would you agree?
Yes, it might be faster considering her in Oklahoma.
Okay. So, would it be appropriate then for the court order that she engage her private insurance to get with you regarding inpatient through that process?
Yes, ma'am.
Okay. And if her private insurance does assessments and inpatient is not recommended, would you be willing to review that assessment?
I will review that with my superiors. Yes.
Okay. And that's all we're asking is that you would review that assessment and you would be willing to staff that and review whatever recommendations are made by that assessment.
Yes, ma'am.
Okay. Pass the witness, Your Honor.
Mr. Nowak.
Thank you so much, Judge Mickey. It's always good to see you. And I just want to read something from Dylan. And Daniel, I'm not waiving privilege. Dylan sent this to me on Sunday. My insurance got worked out. I'm checking in a Senate court tomorrow, so I will not be in court. Please explain to the judge and Mickey that this is what I am supposed to be doing. He wanted y'all to know that. Mickey, again, good to see you. Now, one of the agreements we worked out early October was that Duncan would go to Senate court, correct?
Yes, sir.
And he's in Senate court, correct?
Yes, sir.
The other was when he gets out of Senate court, Duncan would agree to work the Padre program, correct?
Yes, sir.
Including the drug part, correct?
Yes, sir.
And he's agreed to do that, correct?
Yes, sir.
And I know that relapse is never fun, but it's often said it's a part of recovery. You'll agree to me that Duncan didn't try to hide his relapse from you, from the court, or from anybody, correct?
Correct.
And he came asking for help, correct?
Yes.
And that's what we want from parents in this court, correct?
Yes, sir.
Thank you so much, Mickey. Judge, I pass the witness.
Thank you, Ms. Savala.
Miss Lane, with Mom, we've been in this case almost a year. And at this point, we've only had one UA that's negative. Is that correct?
Yes.
Objection, Your Honor. Cause for facts not in evidence and no business records for any results.
I would assume that this has all been testified to in front of Judge Baker as we progress. Is that correct?
No, Your Honor, we always object to the entry of drug test results by word of mouth in a court hearing. I always object to that and is usually sustained.
I'll sustain it.
Ms. Lane, if mom has a job and a house, but hasn't shown sobriety, in terms of our case, are those kids ever going home to her?
No, ma'am.
Objection calls for speculation, facts not in evidence.
I believe that was a scenario presented. Is that correct?
Yes, Your Honor.
Thank you.
As long as it's presented as a hypothetical, Judge, I would draw the objection.
Thank you.
So, a parent potentially could work all the services, sign all the releases, cooperate in every way. But if they're not sober, is that still an issue?
Yes.
I pass witness.
Mr. Trout, any further questions?
No further questions from this witness, Your Honor.
Any further questions from the parents' attorneys?
No, Judge.
Ms. Grant?
No, Your Honor.
Thank you. Any other witnesses, Mr. Trout?
Yes, ma'am. We call Mom Lorna Kirkpatrick.
And Ms. Kirkpatrick, if you would unmute, please, and raise your right hand.
Just a couple of quick questions. When was the last time you used?
The last time I used was in June.
And that's your testimony under oath today that your last use was in June.
Yes.
Okay. When did you dye your hair?
I do my hair every 2 months.
Okay. Did you do that right before you went to drug screen last week?
No, I did it before that. I had roots sticking out when I went to go get my drug test.
Okay. So when was that?
3 weeks ago.
Okay.
Before I was ever told to go test any of that.
Okay. Is your answer still, if in a theoretical situation, if your screens come back that you went for last week, come back as positive, is your testimony still going to be it was June last time you used?
I believe so, yes.
You believe so?
Yes.
Okay. I'll pass witness, Your Honor.
Ms. Grant?
Lorna, did you recently start a good job?
Yes, I did.
And are you required to have a job as part of your service plan?
Yes, I am.
Are you required to have a home that's appropriate?
Yes, I am.
Are you required to maintain a vehicle and auto insurance as part of your service plan?
Yes, I am.
Transportation, I should put it that way.
Yes, I am.
Now, in your service plan, have you had trouble with the times that the lab is open that your screens have been called into?
Yes, I have. I have text messages and emails going back and forth to prove with Mickey. She had sent me to a different lab not stated in my family plan. I told her those times didn't work with my schedule, with me being in school and working, and also in IOP and counseling twice a week, that they are closed during my lunch break. And that is the only time I can go test. She still continued to send me there when I asked multiple times. And then she did agree to change it back to my original testing site, but then she sent the paperwork in wrong. So then got upset and sent me back to the other place. And I have all of the proof of that in text messages and emails.
So bottom line is the testing center that's called out in your service plan is a testing center that has late hours and weekend hours and is open during lunch, correct?
The place that I go to now is open during normal business hours. They don't have any weird hours.
Okay, so which place are you wanting to go to?
DLO Labs.
And is that the lab called out in the service plan or no?
Yes.
And so are you asking the court today to order the department to comply with the service plan by using the lab that is named in the service plan?
Yes.
And that would enable you to test more consistently and without further issues, correct?
Correct.
Pass the witness, Your Honor.
Mr. Trout.
Yes, ma'am. Sorry, Your Honor, I don't, does Mr. Nowak and Ms. Zavala have any questions before I?
Oh, okay. Mr. Nowak?
Just briefly, Ms. Kirkpatrick, where do you work?
I work at a doctor's office, Massengale Eye Care, and I'm currently also in school for medical assistant.
That's all I have. Thank you, Ms. Kirkpatrick. Thank you, Judge. Pass the witness.
Thank you. Ms. Zavala?
Ms. Kirkpatrick, at the beginning of this case, in-person visits were not allowed until there was a negative drug screen, correct?
Correct.
Okay. And at some point, did you provide a negative UA, I believe in February?
Yes, I did.
Did in-person visits start?
They did. I had one.
Did they stop again?
Yes.
Why?
I relapsed.
Okay. Do you understand that until you provide a negative drug screen, that those in-person visits will not start again?
Objection, Your Honor. That's the court's decision, and there's no order stating that. Misstates the evidence.
I don't have. Go ahead.
At the adversary, that provision was put into place that there must be a negative UA before in-person visits because of the fentanyl use.
I don't have that in front of me, so I don't. If y'all want to have a argument about it, somebody's going to have to back me up here. I see Mr. Prout's looking something up.
Judge, we would just concede that she does not currently have face-to-face visits. They're virtual, and that it would be at the department's discretion when to restart those visits. And I assume they would take the drug test into consideration.
Sounds like a pretty good assumption. So right now, everyone agrees that she is not seeing them in person. Is that correct?
Yes, Your Honor.
Correct, Your Honor.
Thank you.
Ms. Kirkpatrick, would it be important to you to see your kids in person?
Yes.
Do you think it would be helpful to provide a negative drug test to do so?
Yeah.
I pass the witness.
Mr. Trout.
When you tested you said October 11th? Is that correct?
Are you asking me?
Yes, ma'am. Last week you tested.
Last week, last Friday.
Okay. At our last hearing in August, you were court ordered to go as soon as you could, provided your foot was healed enough for you to get up and go, correct?
Correct.
Did you notify your worker that you were good enough to go testify, or that you had started working until after that?
I don't understand what you're asking me.
You were court ordered to go drug screen as soon as you could. Did you go do that?
I did go as soon as I could, and
Okay.
I got the correct tests. Yes.
Okay. And when was that?
Whenever I was sent the correct tests.
When was that?
I don't have it in front of me.
Did you notify your caseworker that you had started working a new job?
After I started, yes.
Working? Say that again.
After I started working, yes.
Okay. So you didn't inform her that you were up and about and could go to work and to go drug screen until after the fact, right?
It wasn't intentional.
Okay. I'll pass the witness, Your Honor.
Ms. Grant, any
Can I
follow-up?
ask a couple of more questions?
Go ahead.
Ms. Kirkpatrick, are you willing to contact your private insurance and see if they will pay for an assessment regarding drug treatment?
Yes, and I've already completed that assessment last Monday. I went and did it on my own.
And so we are willing to provide that to Ms. Lane as soon as we get the results, correct?
Correct. Results are in.
Okay. And that will be something we'll be sending over as soon as I review it, correct?
Correct.
And on the relapse, what is your is it IOP or IPO? I'm sorry.
IOP.
What does IOP tell you about relapse?
That it happens in early recovery, and that you don't stop, and that you're honest about it, and you continue to move forward and make steps to move forward. And that's what I have been doing.
And what was the trigger in this case that caused the relapse for you personally?
I had double surgeries.
Okay. And you had to receive medications as a result of those surgeries, correct?
Yes,
And you've signed a release now for the department so they can look into your surgeries and all your medical records, correct?
yes,
Okay. And you actually have received glowing recommendations from your job so far, correct? Your new job?
correct, yes.
Objection, Your Honor, hearsay.
Sustained.
I didn't ask what they said, Judge. I just asked her if she received them.
Okay, I'll allow it.
And do you have any reason to believe that your employment there will not be successful at this point?
No,
Now, inpatient rehab court order today would cause you to lose your apartment, correct?
correct,
Potentially your car, correct?
correct,
And for sure your job, correct?
correct, and school as well. I'd be kicked out of school.
Okay. So, understanding the importance of sobriety, you're willing to work services but are requesting you not be court ordered to inpatient today and give the caseworker time to review the independent insurance assessment, correct?
Correct.
I'll pass the witness, Judge.
Anything further from other attorneys?
Nothing further, Your Honor.
No.
Thank you. Okay, so Ms. Grant and Mr. Nowak, any witnesses?
No witnesses, Judge, rest.
No
Ms. Zavala?
witnesses, Judge, rest.
Thank you. Okay. Anybody have any final thing they want to say about this? It sounds like this is a little ongoing contentious. So
I would like to, Judge, when it's my turn.
You know, I just reiterate the request that we have that mom be court ordered to inpatient rehab. She's worked IOP throughout the life of this case. The sobriety has been a constant struggle. It's not meant to, the request is not meant to punish mom. It is meant to help her with her sobriety because from what we have seen throughout this almost year of this case, it has not worked. And I understand people with addictions and going through periods of sobriety sometimes relapse. I understand that. But this is a case where mom has done well with everything else. We just need to see the sobriety due to the nature of the drug that she's on or has used throughout this case. It is a huge concern. And so that is why we are asking for inpatient to be court ordered in order to try to get mom over this hump in her sobriety.
thank you. Ms. Grant, anything?
Your Honor, my client doesn't have a huge support system. She certainly doesn't have parents that let her live at their house and her placement and stuff as the father does. And we appreciate those grandparents, and we're not suggesting that's not good, Judge. But it is harder when you have had 2 surgeries. You're trying to maintain everything on your own. You've had to move to Oklahoma to separate from the co-parent who you're just not good for each other. You're using together, you know, sometimes distance is the best thing for 2 people who are using together. She has done that. And with the problems we've had with not consistently using the same facilities, getting the drug tests done because of paperwork, we would just again urge and request that she not be ordered to leave her job and lose everything today to go to inpatient until we've looked at that insurance assessment. We know what she's eligible for. We know what the assessment recommends, and we see if we can get this on track through that process. If we do that, Judge, she has an opportunity to complete 6 months of sobriety prior to the new dismissal date in the case, which is what we like to see. And she will maintain housing, transportation, employment, and virtual visits with her children. And we will not be taking backward steps, but we will still be addressing the main issue that we're still having conversations about. And if inpatient's ordered, it's ordered. And if that's what the assessment says, that's what the assessment says. But I think ordering it today, none of us are qualified to say if that's going to fix this triggered relapse. Thank you, Judge.
You're welcome. Mr. Nowak, I assume you're pleased with your client's stance. So unless you've got something to add.
I just wish Ms. Kirkpatrick the best.
Thank you.
Thank you, Judge.
Ms. Zavala, anything else?
No, Your Honor, I would love to see these boys keep both parents in their lives going forward, but I think we are going to have sobriety for that to happen.
Okay. basically, it's always been my stance, and I was on the bench for a long time, that you need that assessment. She's done that assessment. Ms. Grant, you don't get to check it and look over it. You need to turn it over ASAP. Okay. You wanted to review it. The second you get it, it goes to everybody. Okay.
Yeah, Judge, I don't have it in my hands yet, but I will do that. Absolutely.
Yeah. And I want it to come from the facility, not from Ms. Kirkpatrick. It needs to go direct. You need to send those addresses to them so that those cannot be altered in any way. Okay. Everybody got that? Ms.
Yes.
Kirkpatrick, if this continues with the testing issues, the next thing you get to do is a nail bed test. Those are not fun. Don't dye your hair again until you do a hair follicle test. Do not touch it.
Yes, ma'am.
I don't care if you got roots or not. Okay.
I can do that.
Okay. I would highly recommend it. Okay. Well, if that lab is actually stated in the service plan, please continue to use that lab. Apparently, Ms. Kirkpatrick believes that they are an adequate lab, and obviously the plan did. So let's do that so that we don't have any more of this bickering. Let's see. And if the mother's private insurance does not kick in, well, apparently it did for the assessment. So I guess we'll see what it says for outpatient. You're in the Norman, Oklahoma City area. Is that correct?
Yes.
Okay. They should be very creative up there. You should be able to get off work and go straight to whatever you need to check in, do those kind of things. You're in a big city. You ought to be able to find some creative programs instead of just sitting around not doing anything. You understand that?
I'm already in them, ma'am.
Okay. I'd suggest that you stay in them and you make sure everybody's got your attendance records and they're coming in.
Thank you.
I believe that Judge Baker has already granted the extension, but here on the record today, I will go ahead and confirm that this case is being extended, basically because the father's MSA in the mediated settlement agreement as for his stint in Cineor. Let me remind you, Ms. Kirkpatrick, you've got to step up and test negative, or your rights to these children could be restricted or terminated. This is very serious. And I know it's a bad drug, really hard. Can your employer drug test you if they want to?
Yeah, they can.
Okay. Do you have a problem with turning those drug test results over?
I do not.
Okay. Straight from the HR people, not from you?
Correct.
Okay. So we have that on the record, Ms. Lane. You can also request those. So those, if they call their HR people, Ms. Kirkpatrick will let them know you're going to call. All right. Okay. The next hearing in this matter at this time is set for February the 11th at 9. And the judge has a bench trial already set for April the 22nd at 9. If you didn't already have those in your calendar, I can foresee there may be earlier and more hearings in this case prior to those. Anything else today?
Your Honor, just that the new extension date and new dismissal date is April 25th of 2025.
Thank you. I hadn't plugged it in the computer.
Yes, ma'am.
April 25th. Okay. Thank you. All right. Thank y'all very much. Good luck.
Yes, and just so I'm clear on it, we're not court ordering her in today. We're waiting on the assessment.
Yes.
Okay. All right.
Which I think is the appropriate way. I understand where you're coming from, but
Yes, ma'am.
I think you gotta play by the rules.
I understand.
Thank you. We'll go off the record. Mm-hmm.
Judge, this is my last hearing with you today, and it's been a pleasure. I think in 34 years, this is my first deal. And my permission to leave.
Thank you, Mr. Nowak.
Thank
Good
you,
to see you.
Judge, same announcement for me. I'm finished for the day. May I be excused?
Yes, ma'am.
My apologies for the baby.
It's all right. Good luck.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Thank you.
Jay Michelson on behalf of Crystal Richardson, mother. We're present and ready.
Jerry Morales on behalf of respondent father Christopher Moore, Your Honor, present, ready.
Stacy Zavala on behalf of Xavier.
Okay. Is the father on here today? There he is. Thank you.
I'm right here.
Thank you.
Yes, ma'am.
And the mother is on here also?
Yes, ma'am.
Thank you. All right. Mr. Trout.
Yes, Your Honor. Call Mickey Lane.
Raise your right hand, please.
Okay. the parties mediated this case, is that correct?
Yes, sir.
Okay, and at that mediation, it was determined that we were going to request PCA for the aunt who is placement for the child currently,
Yes.
and we're in the process of getting those packets together
Yes.
and getting that all submitted.
Yes.
As part of that, the mediated settlement agreement was, we agreed to a call and recess on this final.
Yes.
In order to, and the MSA, all the agreements in the MSA were subject to the approval or denial of the PCA. Is that correct?
Correct.
And is that what you were asking the court today to do, to call and recess this case, which we've already called it, but to recess this case till we get an answer on the Permanency Care Assistance Program?
Yes.
Okay. Have you started working with those on those packets?
Yes.
Okay. When do you anticipate, and I know they're kind of got to go, there's timelines to get these things done. When do you anticipate being able to get those filed?
November 30th is my first date unless something is rejected.
Okay. And when you say first date, is that for you to submit or for you to get an answer?
For me to have an answer.
Okay. All right. So hopefully by then, nothing will get rejected and we'll have an answer by that point.
Correct.
Okay. All right. Did you receive what I sent out, exhibit number 1?
Yes.
Okay. And can you tell me what that is?
Yes. It's the mediated settlement agreement.
Your Honor, I would ask to admit exhibit number 1 is the mediated settlement agreement that we testified to just a second ago.
Any objections?
No objection.
No objection.
One's admitted.
Thank you, Your Honor. In Your Honor, this one's got a little different since it's is an MSA asking for the call and recess, but at this time, I would ask, unless anybody has other questions, that we recess the case in order to wait on our answer for the PCA program.
All right, seeing there's no objection to that, since that, I guess that's, I did not read it in full. That's part of the MSA. Is that correct?
Yes, ma'am.
What if the PCA is rejected?
Well, and if that gets rejected, then we got to figure out where to go from there. But it is, and that is why this MSA was subject to the approval or denial, because we're going to have to figure out where to go if it is denied. It is a child has some severe health issues, so we're trying to get as much assistance for the placement as we can. If it's approved, we expect to be doing a agreed order and getting this case taken care of before it's recalled.
Okay. No, I have no problem with that. Is there any way? So all you need is the approval, and then you can go forward.
Yes, ma'am. The PCA, once we get approval on the PCA, we can't transfer PMC to placement until PCA is approved or denied.
Right.
If we do that prior to the approval, then it's an automatic denial.
Right.
So
I remember that much.
yeah. So we are, that is what we're waiting on.
Okay. Well, I am set to be back here on the 12th of November. Is there any way that can get moved up so that we can do all that at one time?
That is all kind of out of our hands, I think, Your Honor, because once it's submitted to the state, we're kind of at their mercy to give us the answer on that. So that
could possibly be, you could have your answer by that date. Is that correct?
Possible. I wouldn't say likely, but I would say possible but that would be probably at the earliest. It's hard to say without talking to them on, I guess it depends on who gets it, who reviews it, how quick they are in their answers. So,
and it is in their hands now?
Ms. Lane?
Yes, it's in their hands as of today. Whether they've accepted it or want corrections is pending.
Okay. So, and they have a deadline of the 30th of November.
They require 30 days out from when it's turned in and accepted.
Okay. Well, this is the 15th. So when did you actually turn it in?
This week, but they ask for it 2 weeks before. So if they reject it, then they push it out for 30 days before that. It's the state of Texas rules at the department.
Right. Okay. All right. Well, basically, that's fine. I mean, we'll continue. I mean, this is the MSA in which I've agreed to as to timing for when to have a hearing on it. You can work with Rachel on that then. Okay.
Your Honor, I don't know if Rachel's already said, I've got a note that we got to resume on 1/9, January 9th of 2025 on a 9 o'clock docket.
Yeah, you have a 90-day window and that's it.
Yes, ma'am. And that's close to the 90-day window. I think that is when we were originally set to do it, but we can ask for an earlier hearing if we get an answer.
Okay. Yeah, so then if that's your tentative date, then that's fine. And I know that that's the rule, but I think that if everybody signs off on it and y'all can't get to me, that may not be a huge issue.
Yes.
You can do your homework on that one.
Yes.
Okay. I assume that everyone is in agreement with the MSA as it has been presented to the court. Is that correct to all the attorneys still?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay. So, Mr. Trout, anything further?
Nothing further, Your Honor, at this time.
Okay. Mr. Michelson, anything further from you?
Nothing further. I believe Mr. Trout asked the questions that I would ask.
Okay. And then Mr. Morales, anything further from you?
No, Your Honor.
And Ms. Zavala, you're still in agreement?
Yes, Your Honor. Still in agreement and nothing further.
Okay. All right. This is tentatively set for January the 9th, 2025 at 9 a.m. I'm going to assume that if this gets done at a faster pace, that y'all will try to get this set and out of everybody's hair and get the monies going for this month, for this end.
Yes, ma'am.
Okay. Anything further today? I will grant the request for continuance. This case has begun. This is a final hearing. It will resume prior to the 90 days required by law that it has to be completed by. And anything else today?
Nothing further, Your Honor.
Okay. Just FYI, I'm here November the 12th at 1:30. If you have something, you can pull it in front of me, or you can talk to Rachel about it.
Yes,
Thank y'all
ma'am.
for working this out. Love mediated settlement agreements when everybody's happy.
Yes, ma'am. Thank
All
you.
right. Thank you. We'll go off the record.
Thank you.
24, and if I could have announcements. And I will note that Mr. Hammonds is on the telephone.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Thank you.
T.D. Hammonds for the mother, Misty Lynn Smith Denton, ready to proceed, Judge. She should be joining us by phone as well.
Thank you. I don't see her on there.
Laureen Lucero, for the father, Christopher Roop, Your Honor. I see his name on here, so we're present ready.
Thank you.
Stacy Zavala on behalf of Isabella.
Thank you very much. Mr. Trout.
Yes, Your Honor. I would call Haven Doucette.
You raise your right hand, please. Unmute. There you go. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Ms. Doucette, would you state your name for the record, please?
Haven Doucette.
Ms. Doucette, how are you employed?
I'm a permanency specialist for St. Francis Ministries.
Real quick, how is the child doing?
She's doing very well. I saw her yesterday. She was running around the living room making animal noises. She's gotten new goals in physical therapy, running, kicking, and throwing, and she's excelling those and doing very well. And she's still going to feeding therapy weekly, and she's doing very good in that.
Okay. And she is currently placed with Dad, is that correct?
Yes.
Okay. Dad still doing well?
Yes, he's doing very well.
Dad does well with the child?
Yes.
Okay. Child and Dad bonded well?
Yes.
Okay. Are you today, or is the department asking, as far as Dad's concerned, that Dad be named sole managing conservator of the child?
Yes.
Okay. And at the end of the hearing today, for the department to be dismissed out?
Yes.
Okay. And you do think that that part is in the best interest of the child?
Yes, I do.
Okay. Now move to Mom. you're not asking to terminate on mom today, is that correct?
No.
How is mom doing? When was your last contact with her?
My last contact with her was November 11th. She was asking me about going to an Ozar.
Sorry, you said November 11th. Do you mean October?
I'm sorry, excuse me, October 11th. Sorry.
Okay. How has your contact been with mom?
Very sporadic.
Okay. And what do you mean by that?
She calls and texts me occasionally, and oftentimes it's in circles, so it's hard to understand what she's asking from me.
When's the last time? Now, did you meet with mom face to face on the 11th?
No, it's all my contact's been over the phone.
Okay, so you have never met mom face to face.
That been the case.
Do you know where mom lives?
I do not.
Okay. Has mom ever given you an address?
No.
Okay. When cases are first started with St. Francis and y'all receive the cases after adversary hearings, what are your first procedure? What do you do?
To meet with the parents and create a family plan of services for them to work.
Okay. And was this done in this case?
Yes.
Okay. Did you receive the exhibits that I sent out?
Yes.
Okay. When you got them pulled up, let me know.
Okay, I have them.
Okay. Exhibit number 2. Can you tell me what that is?
Yes. The family plans of service.
Okay. And is that the family plan of service for Misty Smith then?
Yes, sir.
And was this family plan of service filed with the court on July 27th of 2023?
Yes, sir.
Okay. And this was the original, this is a copy of the original family plans file in this court?
Yes.
Okay. And these were made in order of the court?
Yes.
Okay. Mom was aware of the services?
Yes.
Okay. Were these made in order of the court?
Yes.
Your Honor, I would ask to admit exhibits number 1 and 2. Exhibit number 1 is a certified copy of the status hearing order from this court that ordered this family plans of service. And exhibit number 2 is the copy of the family plan of service that was testified to.
Any objections?
No objection.
Okay, 1 and 2 are, thank you. 1 and 2 are admitted.
Thank you, Your Honor. Ms. Doucette, does mom still lack services?
Yes.
Does mom drug screen for you regularly?
Since I received the case, I have not drug screened her, but previously, yes.
Okay. Was there issues with sobriety through this case with mom?
Yes.
Okay. Did she show some drug screens?
Yes.
Okay. And what was mom's main drug that she used?
Methamphetamines.
And so through this case, she did have some negative UAs, but she did have quite a few positive drug screens, correct?
Yes, sir.
Your Honor, I'd ask to admit exhibit number 3. It's a business records affidavit, certified copy that was filed with the court and served to the parties of the drug screens for mom.
Any objections?
No objection, Judge.
No objection.
3 is admitted.
Thank you, Your Honor. And so during this, let me ask you back up. Is mom getting visits at this time?
No, sir.
And why is that?
Due to her providing a positive drug screen.
Okay. Was mom able to work toward getting her visitations back?
Yes.
And what would the prerequisite for that?
She would attend an Ozar and have to go to a rehab facility and provide a negative drug screen.
And has mom done any of those?
She has.
Okay. What did she do?
She did attend an Ozar and she was referred to Cineor, and she was actually kicked out of Cineor due to providing a positive drug screen while in the facility.
And when did that happen?
Let me find the exact date for you. It happened. She went to rehab on May 6th and she was kicked out on May 11th of 2024.
Has she tried to get back into another rehab since?
To my knowledge, no.
Is the department today asking not to terminate mom's rights, but to give mom possessory conservatorship, request a no contact order, and mom to pay child support and medical support at this time?
Yes.
And do you believe that's in the best interest of the child?
Yes, I do.
Is that due to mom not maintaining sobriety in the type of drug that she is using throughout this case?
Yes.
But you don't feel it's since child is going with dad, it's not in the best interest to terminate rights at this time, but a no contact and child support?
Yes.
And is that what you would ask the court to do today based upon what you've testified to?
Yes, I would.
Okay. Were there any other? Give me 1 second. I'll pass witness at this time, Your Honor.
Ms. Lucero?
Your Honor, I don't have any questions.
Mr. Hammonds, any questions?
Please, Judge. Ms. Doucette, from the very beginning of this case, was it obvious that Misty Smith was operating at a low functioning intellectual capacity?
Yes, sir.
I mean, we have done some intellectual screening. Is it your understanding her IQ testing has indicated she operates with about a 70 IQ?
Yes, sir.
Judge, I have no other questions.
Ms. Zavala?
Ms. Doucette, mom's visits have been stopped since the very beginning of March. Is that correct?
Yes, ma'am.
And as far as you can tell by the records, was she informed of what she needed to do to get those visits restarted?
Yes, ma'am.
And even when those visits were being held, did mom struggle in terms of Isabella's feeding issues?
Yes, ma'am.
And while those feeding issues have got, well, would you agree that those feeding issues with Isabella have gotten at least some better?
Yes, they have.
She's making progress. She can eat some real food and things like that.
Yes.
But mom had lots of work during her visit. She had a feeding therapist that was there regularly for visits. And was mom ever able to get down what needed to be done in order to properly take care of Isabella?
No, ma'am.
Is it a concern of St. Francis that mom is continuing to test positive for meth?
Yes.
And have you seen Isabella in the home with Christopher?
Yes, I've seen her in the home.
Okay. Would you agree that she's well bonded to him?
Yes.
Do you have any concerns at this time for dad being named sole managing conservator?
No.
I pass the witness.
Anything further of this witness, Mr. Trout?
Just to reiterate real quick, Your Honor, Ms. Doucette, and I know I've asked this question a couple of times, but just one more time. Department's asking for dad to have sole managing.
Yes.
Mom to have possessory, no contact, child support set at minimum wage, and medical support of $50 a month.
Yes, sir.
And for the department to be dismissed out at this time.
Yes, sir.
And due to the nature of the bonded relationship with dad, and how well the child's doing there, you believe that's in the best interest of the child?
Yes, I do.
Thank you, ma'am. Nothing further, Your Honor.
So, Ms. Doucette, because of the IQ of the mother, does she receive Social Security disability payments?
Yes, ma'am. She is on disability.
Okay. And do you have any idea what that amount is?
No, ma'am, I do not.
Would you agree with me that it's less than minimum wage?
Judge T.D. Hammonds here. I can inform you she receives about $600 a month since she was about 17 years old. She's now 38.
Okay. Her child support needs to be set commensurate with that, not minimum wage.
Yeah. Sorry about that, Your Honor. Yes, ma'am.
So, I don't know what the standard is on that, but, I think that probably, does she have any other children?
From what I'm aware, she has.
Judge,
Oh, sorry.
Yes, sir.
Judge, she has a 14-year-old that she visits with, much like the department is asking for visitation. In this case, it's supervised visits.
Okay. Well, they're asking for no contact in this case.
And Judge, I have no objection to that until she starts providing some clean UAs. I mean, I agree with that.
Okay. All right. So what do you, as her attorney, we're sort of getting off scale here, recommend for a child support amount then?
Judge, if they're going to ask for $50 a month medical support,
yeah, they're not going to get that.
okay.
That's a fourth of her paycheck.
Yeah, I mean, I would suggest $50 a month, Judge. I mean,
Total?
Yeah, she has an apartment, but that's pretty much all she can afford. So.
Right. And it's subsidized, I'm sure.
Yes.
Okay. All right. Okay, thank you. Any further questions of the caseworker or whatever they call them now? Yeah. Okay.
No, Judge.
Okay. Ms. Lucero, any questions?
Not for this witness, Your Honor.
Okay. All right. Any other witnesses, Mr. Trout?
No other witnesses, Your Honor.
Okay. Then Ms. Lucero, any witnesses?
Your Honor, I have a couple of questions for my client, Mr. Root.
Okay. Mr. Roop, if you could unmute. There you go. Raise your right hand, please, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. Go ahead.
All right, Mr. Root, you've heard what the department is asking for, that you be named sole managing conservator of your daughter and Ms. Smith to be named possessory conservator of your daughter. Are you in agreement with this?
Yes.
Okay. Now you've heard also testimony regarding child support and medical support. The medical support goes to the state, so you really don't have a say in that. But what are your thoughts on child support? Do you need that child support for Isabella, or what are your thoughts on just the child support amount?
I really don't need it.
Okay. All right. So at this time, because it'll be a minimal amount, and you heard what her income is. So would you be okay with just waiving the child support and that she just be ordered to pay medical support?
Yes, that'd be fine.
Okay. All right. I'll pass the witness.
You can mute it. Thanks. Okay. And then Mr. Hammond, anything?
Just a couple questions, Judge. Mr. Roop, have you had any contact with Misty since about March of this year?
No, not really.
I mean, do you know her phone number? You know her address?
I don't believe I know her phone number. I know she has an apartment.
All right. Is it safe to say that Misty will drop out of sight for months at a time? Nobody knows where she is.
Oh, absolutely. That is true.
Are you confident that you can abide by the terms of the visitation, which would be until Misty provides you with some clean UAs, you understand you do not have to allow her, well, you will not allow her to have any contact with Isabella.
That is correct.
I mean, she's going to have to jump through that hoop before that even happens, and that puts the burden on her shoulders, not yours. You understand that?
I do.
All right. I have nothing further, Judge.
Thank you. Ms. Savala, any questions?
I've got no questions for Mr. Root.
Thank you. Okay. Then Mr. Hammonds, do you have any witnesses?
Judge, unless you tell me Misty has joined us by phone, I have no witnesses.
I don't think Rachel's thrown her in here, so I think we're good.
All right. I have no witnesses, Judge.
Thank you. Ms. Savala, any witnesses?
No witnesses, Your Honor. I just did want to let you know that I got to visit with Isabella twice in the home with Dad. She's clearly very bonded and got to see them continuing with the therapies that she needed. And I've got no concerns about what's being requested at this time. I do believe that's in Isabella's best interest.
Good. Thank you very much. Okay. Is there anything further before the court today? Mr. Trout, anything else?
Nothing further, Your Honor.
Okay. Then the court will order that the father be named the sole managing conservator, that the mother be named possessory conservator, that there is a no contact order with the proviso that if the mother becomes better, then of course the father can access visitation as he sees fit. Of course, this case would now go into the district court rather than CPS court if there were some issues. The father has stated that he does not need any child support. I'm going to take him on his word on that. I am going to order $25 a month for medical support, so that'll keep the Attorney General's office at bay and not go after any issues for a while. Anything else that I'm leaving out? And dismiss the department and all ad items.
Yes, ma'am. I believe that's it.
All right. Well, that's a great way to go to lunch. Congratulations, Mr. Roop. You are a true daddy now. So y'all have a good lunch.
This
And
is
we'll go
the
off the record.
Richardson
Bye-bye.
matter. And
Thank you,
Mr.
Honor.
Hamker, before I actually call the case, I think I have to take up your motions.
Thank you, Your Honor. Your Honor, one of the motions that I filed is probably not pertinent at this point due to the fact of some of the facts that have transpired in the case. I had filed an objection and motion to removal of the child from my client's care. I think that child has now been removed, so that particular motion probably is not relevant at this time. So I will withdraw that motion.
Okay, thank you.
I did file a motion, Your Honor. This is a complex family case, has many issues. I regret to say it, but in the 40 years I've been practicing law, I have never seen a child custody case short of death with more tragic child abuse, torturous child abuse in a family than I have seen in the records that have been filed by CPS. That's one of the reasons why my client has been so earnest. She does not want this innocent baby to go the route of countless other children born with, if you have not had the opportunity to read the permanency report filed by CPS on September the 25th, 2024, that report sets forth in it child after child and the atrocities that have been done to them both physically and by pedophiles year after year after year. I could not stand here and not file something in this case without hopefully bringing it to the attention of the court. I hope that the state CPS has brought it to your attention. If not, I ask the court, no matter what you do on any of my pleadings, before you rule on anything, you read that report that the state filed showing what kind of people that we're
Objection, Your
dealing
Honor.
with in this case.
I'm sorry, Mr. Trout.
Objection to that last statement, Your Honor. I mean, we're on the Richardson case and you were, yes.
Anyway, and for that reason, Your Honor, I filed an objection and motion for continuance in this case. I was under the impression Judge Baker was going to be hearing this case. I've been in Houston and just got back late last night. Nothing against you, but this is a complex case. I think judges, when they hear a case and have been with it since the very beginning, they know who the parties are. They have a feel for what's going on. And I think it's unfair to you as a judge to have to make a ruling on this type of case. And I think it's unfair to the child. And that is my other motion for you to rule on. It's either going to be agreed to or denied.
Thank you. Mr. Trout, did you have any responses?
Yes, ma'am, Your Honor. As far as the objection and motion for continuance that was filed today, at this time, Ms. Hamker does not have any standing to make any motions or to ask for any continuances in the case. He is not a party in this case at this time. The main pleading, I believe, that needs to be discussed today would be the petition for intervention that was filed back in September. Mr. Hamker and his client don't have standing at that time to file. They still don't have standing till this day to intervene into this case. His client is a very good foster parent. She has done a great job. I'm not taking anything away from her in this case. But parents have been ordered, we were ordered to mediation. We were able to come to an agreement in mediation at that time. An agreed order has been filed with the court, signed by all parties and the mediation agreement attached. But Mr. Hammaker and his client do not have standing to intervene into this case at this point. The child was not in the home with the foster parent for the 12-month period that is required of a foster parent in order to intervene into the case. So we would ask that all pleadings be struck and them to be dismissed and us to finish our hearing today.
Your Honor, with all due respect, I'm just focusing on the one motion for the continuance, and then I would like to move on to my petition for intervention. I know counsel has argued both, but I'm focusing on the one at this point in time.
Well, unfortunately, sir, you can't bootstrap into a motion for continuance when you actually are not in the case. So the motion for continuance is denied.
All right. May I present my evidence on my intervention?
Unless you have something that's going to refute the 12 months.
Yes, Your Honor. The pleading that I filed, and it's curious to note, I filed on two different points. The state has responded on one point where they have filed that I did not meet the 1 year requirement. My client is 72 hours short of having the child for a year. That's true. But the other point that I filed on was, and which no response has been made, so I assume it's been waived since we've started this point, is 102.004, standing for an other person. Under B, it just says that if the court deems that another person has substantial past contact, then they may grant it subject to B1 if applicable. If you go over to 102 and you go to the B1 under C, that talks about where a child has to be eligible to be adopted before there's any other requirements other than substantial past contact in my reading and interpretation of the law. So I would like to put my client on the witness stand to prove up her substantial past contact. I assume there's no need to put on any evidence regarding the worthiness of the parents, since the state has not allowed them to be a managing conservator, either singularly or combined, but I'll be glad to elicit what testimony I can. But I think my client has the right under the law to file and argue and ask the court to consider them as an other person, since my client has taken care of this child more in its life than anyone else.
Well, Mr. Hamker, I believe that you are overreaching the jurisdiction. The judicial district that you are in has not ruled that you can go beyond reading the foster parent. There are some judicial districts in this state that have. I believe they're a little south of Amarillo, but your district, your judicial district, has maintained that foster parents must meet the 12-month rule. Even if you go under the 102.004B1, it still bootstraps back to the 12 months for the foster parent.
Your Honor, I agree with
in Amarillo, sir, you have no standing.
Your Honor, I would agree with you if that child is eligible to be adopted. But at this point in the child's life, it has not been listed as a child eligible to be adopted by CPS.
If you read some of the actual reports, in those clarifications as to primary, and then I can't remember the second word, whatever the second condition is, adoption is in there, and they have stated that that has been a consideration. That has been withdrawn, and apparently there has been, and the policy of the state of Texas is to keep families together as much as possible. So I'm going to have to rule against you today, sir. You do not have standing to intervene in this case. You have not met the 12-month rule, and I think the child has been taken out of the home, so you're not even close to the 365 days. Is that correct?
The child is no longer in the home.
Okay. Sorry, Mr. Hamker. It was a valiant effort, but the time clock got you.
Your Honor, I would ask one thing. I'm just an old rancher that practices law. And even though we're exiting this stage and probably never see you again, I would ask that you read that one report regarding all of the atrocities that have happened to children born into this family. And I would pray that you take that into consideration whenever you make your ruling, whatever it may be, on the rest of this case.
Thank you, sir. I appreciate it. It was very nice meeting you. And under other circumstances, it'd probably be much more pleasant. So thank you.
May we be excused?
Yes, sir, you may.
Thank you.
So now that we've taken up the motions of Mr. Hamker, then let's go on the record further and make announcements for the actual final hearing in this case. If I could have those, please.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Thank you.
Savannah Kincaid, I represent Ms. Pineda. We're present and ready.
Maureen Lucero for the father, Taurus Richardson, Your Honor. We're both present, ready.
Stacy Zabala on behalf of the child, you're ready?
And I do have a CASA, isn't that correct?
Yes, Your Honor. Thank you. We have Anna Pineda, who is the actual advocate, and I'm Carla King with a volunteer supervisor.
Thank you very much. Mr. Trout.
Yes, Your Honor. As mentioned earlier, we have filed, all parties were sent to mediation. We did reach an agreement. That mediation settlement agreement was filed with the court on 9/23 of 24. We've also filed as of October 9th of 2024 an agreed order that has that mediated settlement agreement and all stipulations attached to it and in the order that was filed with the court for their consideration and approval. But having said that, if we want to prove up as far as what the agreement is, I would call Erica Cantrell, Your Honor.
Thank you. Ms. Cantrell, if I get you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you.
Ms. Cantrell, state your name for the record, please.
Erica Cantrell,
And Ms. Cantrell, how are you employed?
the lead permanency specialist for St. Francis Ministries.
And you worked on the case and were a party to the mediation on the case involving the child, Lazarus.
Yes, sir.
Okay. And at mediation, did the parties come to an agreement?
Yes, sir.
And the mediated settlement agreement was filed with the court on 9/23 of 24, correct?
Yes, sir.
Per that mediated settlement agreement, the agreement was that permanent managing conservatorship go to the department.
Yes.
Okay. That mom and dad stay possessories.
Yes.
That in this case, dad, who is Taurus Richardson, would pay child support of $175 a month beginning on November 1st.
Yes, sir.
That at this time, mother will pay no child support in this case. Is that correct?
Yes, sir.
Okay. Additionally, father would pay medical support of $50 a month beginning on November 1st.
Yes. Yes, sir.
And mother would pay child support of $25 a month beginning on November 1st. Is that correct?
Yes, sir.
Okay. There was also a step-up visitation plan put in as starting with father, that he will have possession of the child as follows. Once father completes 3 BIP classes, his psychosocial exam, 3 counseling session, and 3 parenting classes, he'll be able to have 30-minute weekly 30-minute virtual visits with the child. Is that correct?
Yes, sir.
Okay. And then once he additionally completes 3 more BIP classes, he'll be entitled to continue the virtual visits. And if he's able to travel to Amarillo, have 2-hour supervised visits with the child by St. Francis or his parents who are placement of the child at this time.
Yes, sir.
Okay. Or a designee approved by the department.
Correct.
And he shall continue to have those services and should continue to work services including requested drug test. If he tests positive, the in-person visits will stop until he provides clean UAs.
Correct.
Okay. As mom, once final order has been put in and signed, shall have weekly supervised visits of 4 hours for a period of 3 months with Linda Del Toro, who St. Francis or a designee of St. Francis to supervise the visits?
Yes, sir.
Okay. Then she shall have 4 hours visits specified above, additional to 2 hours of unsupervised.
Yes, sir.
And she'll continue to work her services as directed in the service plans, including drug screening and alcohol test.
Yes, sir.
And if she tests positive, she'll be returned to supervise for 2 hours each.
Yes, sir.
And is that the agreement that was reached at the mediation?
Yes, sir, it was.
And today, are you asking the court to follow that mediation settlement agreement and incorporate that into the final order?
Yes, sir.
And do you believe that's in the best interest of the child?
I do.
Child was moved to paternal grandparents' house. Is that correct?
Yes, sir.
And at this time, everything is going fine.
Everything is going good. There wasn't any fear or discomfort. I mean, nothing indicating that he didn't feel safe being placed there initially. So as of right now, everything is going really well. They're just building their relationship with him.
Okay. And again, best interest of the child. Child's doing well there, and asking that the agreement be followed.
Yes.
Thank you. I'll pass the witness, Your Honor.
Thank you. Ms. Kincaid?
No questions, Your Honor.
Ms. Lucero?
No questions, Your Honor.
Ms. Zavala?
No questions, Your Honor.
Thank you. Any other witnesses? Mr. Trout?
No further witnesses on this case, Your Honor.
Ms. Kincaid, any witnesses?
I'll call Miss Pineda.
Ms. Pineda, if I get you to raise your right hand, do I see you anywhere? Is she on here?
Yes, ma'am.
Oh, there she is. Hi, Ms. Pineda. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Miss Pineda, you just heard Miss Cantrell's testimony. Is that correct?
Yes.
And you heard the mediated settlement agreement.
Yes, ma'am.
And is that your agreement?
Yes, it is.
Okay, thank you. I'll pass the witness.
Mr. Trout?
I have no further questions. No questions of this witness, Your Honor.
Ms. Lucero?
No questions, Your Honor.
Ms. Zavala?
Miss Pineda, I know we have talked about this before, but you do understand that since Lazarius is placed with grandparents, that doesn't change your visitation with him. Correct?
Yes.
Meaning you can't just show up over at grandparents' house anytime you want, right?
Absolutely. Yes, ma'am.
Right. And you understand that, and we've discussed that in depth.
Absolutely.
Okay. No further questions.
Thank you. Any other witnesses, Ms. Kincaid?
No, Your Honor, I rest.
Ms. Lucero, any witnesses?
I'd like to call Mr. Richardson for a couple of questions, Your Honor.
Okay, Mr. Richardson, if I get you to put your camera on, please, and unmute. There you go. Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead.
Could you state your name for the record?
My name is Tice Richardson.
Okay, Mr. Richardson, you heard the testimony regarding the mediated settlement agreement that we have now signed off on an order. Did you hear all the information that Ms. Cantrell stated?
Yes, ma'am, I did.
Okay, and are you in agreement with what was stated regarding your visitation, what you'll need to do, and the child support and medical support that you'll need to pay?
Yes, I understand.
Okay, and your son has been placed with your parents, correct?
Yeah, I guess. Yeah.
Okay, and you understand that, as Ms. Zavala was asking the mother, you just can't show up at your parents' house to see your son. You understand that?
Yes, ma'am.
Okay, you'll have to go through the steps in order to gain the visitation that you agreed to. You understand that?
Yes, ma'am.
Okay, I'll pass the witness.
Mr. Trout?
Yes, ma'am. Thank you, Your Honor. Mr. Richardson,
Yes, sir.
can you hear me good?
Yes, sir.
Okay. Mediated settlement agreement was put in. You understood all those. Looking back, I don't believe you've ever been legally adjudicated as the father. In the agreed order states that you are being adjudicated as the father. You're okay with being adjudicated, correct?
What does adjudicated mean?
Legally being named the father of the child.
Oh, yeah.
Okay. Do you have any dispute on that?
No, it's fine.
Okay. Do you and maybe the court should ask this instead of me, but do you want to speak to your attorney about that to make sure you understand the ins and outs on that?
Yeah, if it's okay.
Okay. Sorry, Your Honor, this is something that just popped up that I realized was not addressed earlier, so that's why I asked these questions.
Sorry, y'all.
So you're, okay, so you do not want a paternity test, or you do?
Oh, no, I know that's my child, Your Honor.
Okay, so you're in open court today saying, I want to be named the legal dad.
Yes, Your Honor.
Okay, great. Thank you. Ms.
Yes,
Kincaid, do you have any questions of Mr. Richardson?
No, Your Honor.
Okay, and then Ms. Zavala.
Mr. Richardson, I'm going to go a little bit further than your attorney. I know that you said you understand you can't just show up, but I want to make sure, do you understand that if you show up at your parents' house, that risks him being removed from your parents?
Yes, I understand.
Okay, nothing further.
Thank you. Thank you, Mr. Richardson.
Yes,
and then Ms. Zavala, do you have any witnesses?
No, Your Honor.
As the ad litem, are you in agreement with this?
I am, Your Honor. I do believe it's in the best interest of the child.
Okay, and you have spoken to CASA and they are in agreement also?
I have, yes.
Okay. Does anyone else have anything further today?
Your Honor, I have a couple of things I'd like to say.
Oh, sure.
All right. Your Honor, in this case, we came down to the end here where the foster mom had, tried to intervene. We already took up that issue. I just wanted to address, since the beginning of this case, and I know that you weren't on the case, the paternal grandparents had asked for the child to be placed with them. They failed, well, not failed, but their initial home study was denied on, well, of course, what I feel were minor grounds. They weren't, until we got towards the end of this case, there was no communication, from what I understand, between the department and paternal grandparents. So there was never an opportunity to fix whatever issues the department thought that existed at the time. So that's why we got so into the case. Foster mother became more bonded with the child. But I just feel that, I would ask that if there's a family, member that fails or has a home study denied, that, the department reach out to them on a more regular basis to see if it's issues that can be addressed or cannot be addressed, and rather than get this deep into the case. So that's what I just wanted to bring to the court's attention.
I believe they call that rehabilitation, don't they? Okay.
So,
well, maybe we all learned a lesson because this got very close to the 12 months.
Yes, ma'am.
So hopefully St. Francis has learned one. I know everybody's still on a learning curve.
that's all I have, Your Honor.
That's fine, and a very valid point. Anything else? Okay, then I will bring forward the mediated settlement agreement as stated and proven up here in court. I will approve that. I'm going to assume that somebody's going to talk to the grandparents about things that they can do in case this case falls back on them, as far as kinship funds and things of that sort. Has that been done by St. Francis?
I'm sorry, the kinship, let me start over. We do have kinship that has gone out to the home and done some assessments and worked with them. So I think as long as we're formally involved in the case, they will assist and continue to help until we are officially dismissed. So they're going to have a lot of support until that day.
Good. Thank you.
Yes, ma'am.
Okay. All right. Anything else today? All right.
Your Honor, may I address the court for a moment, please?
I'm sorry?
I just need to stand corrected with Casa. Is Julissa Castillo is on, she's the advocate, not Anna, but I did want to say that regarding this case, we like to bring out family strengths, and Miss Pineda, the mother, she has really made significant progress in completing her family service plan. And I just wanted the court to be recognizing that with her. I also want the court to understand too that CASA does go back out and we do check on children monthly. We have gone to the grandparents' home, and it seems the bonding is going quite well with Lazares.
And you're going to stay in the case?
Yes, Your Honor. Thank you.
Good. Thank you. Okay. Sounds like y'all got a good mediated settlement agreement, and hopefully the department won't stay in this forever, one way or the other. So, anything else? There will be a hearing. I guess we're going to go ahead and do it at 3 months instead of 6. It'll be for January the 2nd at 9 a.m. Probably be a good time to check in.
Yes, ma'am.
All right. Thank y'all very much. We'll go off the record.
Thank you.
If you're here on Solis, stay here.
And Judge, real quick on that one, I know we discussed it. I didn't know if you officially said you were adjudicating that.
Oh, I'm sorry. Go back on the record. Sorry, court reporter. I am going to find that the father has admitted in court and will adjudicate him as the legal father.
Thank you.
Thank you. Thanks for reminding me.
Yes, ma'am.
Your Honor, can Mr. Richardson and I be excused since our case is done? Thank you.
Everybody can leave but the next case. Okay, you want to pop in and see if Joel's got something going there, Mr. Trout?
Mr. Jackson is in the waiting room, Judge. He
Uh-huh.
finished with his client, so I'm going to bring him back in, and I'll bring his client out of the breakout room.
Okay, you're going to bring the client in with him, or you want to? Does he want to talk to Mr. Trout, or are we just going to do this?
I'm not sure if we can bring him in and see what he wants to do.
Yeah, leave the dad in the waiting room and let him come out.
Okay.
Yes, ma'am.
Did you get to know your client really well?
A little better.
Yeah. Do you need to talk to Mr. Trout, or are we just proceeding?
Probably, is Mr. Solis still in a waiting room, did you say?
I don't know. Rachel.
Yes, he's in the waiting room.
Yeah.
Okay, well, Judge, I don't think so. There's just a matter of business that I'll need to take up with my client after we've made announcements.
Oh, okay. So you're ready for us to pull him in and do this?
Yes, ma'am.
Okay.
Cineor Trout for the Texas Department of Family and Protective Services. We are present and ready, Your Honor.
Thank you.
Savannah Kincaid, I represent Miss Pineda, and we're ready.
Joel Jackson, on behalf of the father, Neil Solis, we're present. At this time, not ready. My client has an announcement, has asked me to withdraw as his attorney. I will tender my client to the court for his explanation.
Okay. So let me go ahead and finish announcements, and we'll go with him.
Stacy Zabala for the Solis girls.
Thank you. And I believe CASA is in this case also, correct?
Yes, Your Honor. Thank you.
Thank you. Okay, Mr. Solis, it's my understanding you're asking, I guess, to represent yourself.
Yeah, myself, or to get a replacement. Yeah, one or the other.
Okay, so you do not want Mr. Jackson to represent you?
No, ma'am.
Okay.
This was the decision that was supposed to be made after the second court hearing that he missed. If I would have had access to the courts, if he would have done his job and had me, the right paperwork put in for me to actually come in front of you in the court and make this announcement, it would have happened a long time ago. But since it happened at the very last end of the court date, I have to go ahead and use this time to do it now.
Okay, so are you asking for another attorney, or are you going to represent yourself?
Another attorney.
And have you done anything to reach out to Mr. Jackson to attempt to send him your information and work with him?
Many a times. Through letters, through phone calls from my family, and it's just always the same thing. No. His answers are always, I don't know. his answers are always, I did it, but then it doesn't get done. And this is talking about me actually stepping in front of the courtroom. This case has been going on for a year already, and this is my first time I've actually been able to step into your courtroom, ma'am. I mean, that's just not correct. That's not right. It's not acceptable. The very first time that he missed the first court date, I wrote him an extensive letter saying, that the things that happened in my son's case, I could not allow to happen in my daughter's case because my daughters have actually been molested, and that I needed somebody that was going to defend my rights. I was going to step up and put some work into it. And if he was unable to do it, then to go ahead and excuse himself. He said he was able to do it, and this is what we had, months down the road.
So, Mr. Solis, have you been working your service plan?
That's the other thing I'm glad you brought up, ma'am. This unit that I'm not in the same unit when this case first started. So this unit I'm on in February, I made it very, very known to Mr. Joe Jackson and to my caseworker at the time that this unit has a lady that specializes in CPS cases, and she puts people in parenting classes that have an open date, get priority to go inside the parenting classes. They needed to speak to my caseworker. I would say Avery probably got in the case since last month, so 10 months out of the 12 months that I've had this case open, I've had a caseworker that I have not been able to be in contact with. There's been zero communication. There's been numerous letters written to her that have gone unanswered. There's been phone calls that just have not either, the contact information is no good on some of them, so we've had to go online and look up this information. And when we're finally able to get a number to this lady, there is no answer. There's no response. There's for the last 10 months. So the only thing that I could have done, which was my parenting class, I was able to do because of the lack of job performance from the department.
Okay. So, Mr. Jackson, do you have any response?
Ma'am, I had we had some phone contact with Mr. Solis. I know that I'd written him some letters in his other case dealing with Andrew Solis Jr. This idea about him talking about wanting me to withdraw today was the first I've heard about it. I had a meeting scheduled for him. It was a phone call on April 1st of 2024. Had it scheduled for the prison. Through the prison, they set up the phone call. At that time, Mr. Solis said that he didn't want to talk to me or talk to anybody. And that was on August the 1st. On August the 5th, I'll just read you. It says, we submitted a revised order to the judge to sign, which has not yet been signed, but we had a typo on the original order. This is for him to appear, by the way. Mr. Solis's hearing is tomorrow at 9 a.m. Mr. Jackson understands that Mr. Solis does not want to talk to him, but he will appear at the hearing tomorrow on behalf of Mr. Solis. He just wanted to confirm that he would get information for the hearing, even if he does not wish to participate. So I have tried to reach out to my client. Also, we had mediation. I don't have the date for it.
Oh, that's fine. That's fine.
And suppose if he wanted me off the case, he could have asked them at the mediation as well. I'm not opposed. If he wants another attorney, I'm not opposed to that, Judge.
Well, it sounds like Mr. Solis has decided that he maybe wants to work his services, and it sounds as though he at least knows who to talk to and who to set those up with in the system. So I think that every parent should be afforded their right to attempt to complete their services. And
yes,
I don't know that it's so much you as maybe now Mr. Solis has decided to step up and attempt to do this. I don't know, and I don't want to hear from the caseworker, but the caseworker obviously has heard what Mr. Solis has said, and that he is now interested in working his services, and probably should be sent a lot of packets to work But I see that we're in the first 12 months. I think that the mother already has an agreement, so that's probably can just stay in place. There is an aunt that the child is placed with. Is that correct? To whoever, maybe Mrs. Wally, you can answer me.
The children are not placed with the aunt yet. That is the hope going forward. They are together and they have regular visits with the aunt and their siblings.
Okay. Well, as all you attorneys know, these are the kind of cases that can come back and get you. So I think that let's go ahead, and since there's basically an agreement with the mother, if Mr. Solis wants to attempt to at least keep his toe in the water, because it's my understanding, Mr. Solis, that you're not getting out of prison anytime soon. Is that correct?
I mean, I'm under review right now, ma'am. I'm under review right now, so that's still up in the air. I mean, I could make parole, any day now. I'm for review right now. So
what are you in prison for?
For a drug possession.
Okay, so when you got out, if you got out while this case is still pending, that you would have totally restricted visitation, and you would have to go by the rules of the court. You understand that?
I mean, I have no problem with that, ma'am. I'm willing to do whatever I got to do to get my girls back. I mean, that's the main thing that I've stressed to all 5 of my caseworkers and my attorney. If this has been going on right now, and I was not incarcerated, ma'am.
I don't need to hear the rest of it. I'm going to grant your request. I'm going to grant an extension in this case strictly because of extraordinary circumstances that you have not been afforded the opportunity to work your services in your prison. But I'm telling you now, sir, you are to work them. If you do not work those services, your rights to this child will be restricted or terminated strictly because you didn't work your service plan. You just sat here and told us on the record that that's what you want to do.
Man,
right?
that's been the thing since day one. I mean, it's not something I just woke up today and just changed my mind. That's something that I've been doing since day one.
Mr. Solis, I just want you to understand that you have just put your foot in that door and that you've told us that's what you're going to do. You understand?
Yes, and also, can there also be an order, too, that I have communication with my daughters? I mean, I've not had that. I mean, my
children do not have communication with prisoners. If you want to write a letter, send it to your caseworker, you can do that. Anything else?
So I'm not able to have communication with my daughters then?
No, sir. You can write letters to them, to her.
Or to them?
To them, whatever. You can write letters to your caseworker, directly to your caseworker, and your caseworker will review them to see if they're appropriate.
And how do I know these? And how do I know these letters are actually being sent to my daughters? I mean, I don't have no communication. I have no interaction with this new caseworker I do, so I can't sit there. But the last ones, I mean, how do I know they got that to my daughters?
Sir, they are the temporary managing conservator of your child. They are ordered by the court to follow the court's directions. That's the best assurance you're going to get.
But I mean, they don't follow they do whatever they want to do. The department does whatever they want to do, ma'am.
No, sir, they do. No, sir, they do
whatever they want to do. I mean, they've been doing it the last 8 months, the last 10 months. They've been doing that, whatever they want to do.
Mr. Solis, don't argue with me. I'm just
saying. I mean, they don't do. You say that's my only. What did you say? My only
communication. Yes.
No. I'm saying you said I have to take that word for it because your word is bond, but they don't follow your word. They don't follow your orders. So I mean, that doesn't really give me any reassurance, ma'am.
Well, they all run the risk of losing their jobs then if they do that, sir. They are by law but they will read your letter and they'll see if it's appropriate and they'll go over it with the attorney ad litem and the CASA. So it's not like you're not going to be screened on your letter.
It's just this last year that I've been having this case with this department. Haven't had no communication with my caseworker, so that's a violation of your order.
Mr. Solis, I'm going to give you an attorney. Your attorney will contact you, and you will talk to them. If you refuse to talk to them, then
I don't refuse to talk to anybody, ma'am. I don't refuse to talk to anybody. When I refused Joe Jackson, that was because he missed a court date. That's the reason why. I mean, what is there to talk to him about if he doesn't put me in the courtroom so I can get rid of him? I mean, that's there's no need to talk to him, man. I mean,
Mr.
that's the only
Solis,
reason why.
Mr.
The reason I
Solis,
denied his visit.
Mr. Solis, I'm going to mute you if you don't listen to me, okay? You are getting what you want. You're getting a new attorney. That attorney is going to contact you as soon as humanly possible. This case is going to be extended for 180 days. That is the maximum that it can be done. Do you understand that? Yes or no?
Yes, ma'am.
Okay, then that's what's happening today. Okay, that is all that you need to know. You'll have an attorney. I'm going to allow Mr. Jackson to withdraw. The other agreements will all remain in place, and you will have an opportunity to work your services and talk to an attorney.
Okay.
Do you understand that?
Yes, ma'am.
Thank you. Does anybody else have anything before the court today? This case will be extended.
Judge, I just needed to ask if Miss Katie is going to prepare that order, or if I need to prepare an order on the withdrawal.
It's not your withdrawal, it's the court. So if Miss Katie would do that, that would be fine. She could have Judge Baker sign it.
Yes, ma'am.
And go ahead and substitute Rachel when you do that. And then they won't have to do two orders. They'll substitute you out.
And I will send Mr. Solis a copy of that order.
Good. Thank you. That would be perfect. There is a hearing already set for January hold on, let me get over here. Yeah, January the 2nd at 9 a.m. Y'all may need a hearing before that, but that's what's on the book right now. Or Rachel, do you want to set that a little bit different? Because that looks like it's with a bunch of permanency hearings.
Hey, Judge, if I may,
yeah.
I've got a worker here. If we want to do a quick review right now, I can do a review order and have today as a review.
That would be great. That'd save that for you, wouldn't it?
Yes, ma'am.
Okay. Before we do the permanency review, does anybody else have anything outside of that room?
No, ma'am.
Okay. So,
Your Honor, do you want me to stay on for the review hearing?
No, sir. You are free to go. Thank you very much.
Thank you.
Good to see you.
Yes, ma'am.
So, Rachel, while we're doing the review hearing, if you want to look for another hearing date and go ahead and put the extension in there, so we'll have the drop dead date on that. That'd be great.
Yes, ma'am.
Okay. So, who do you call on this, Mr. Trout?
Erica Cantrell, Your Honor.
Okay, Ms. Cantrell, I just swore you in a minute ago. I think you're good. If you'll unmute and give us your report.
Ms. Cantrell, if you would update the court on how things are going with the Solis children.
Yes, sir. The girls are doing great. They are placed together in Lubbock. They have been for quite some time. They are, if I believe correctly, they are placed in the same cottage now. So they are getting to spend some regular time together. They're very bright, very smart. They know what they want. They're very free to voice what they want. So school is great. They're just really good girls.
Are they in what type of services are they involved in? Counseling at their placement, or what do they have going helping them?
Yes, they both receive individual counseling just to kind of work through the reasons of removal, some stress, some anger, things like that.
And those counseling sessions have been going well?
Yes, they do.
As mentioned, we did mediate and we do have an agreement with mom at that time.
Yes.
And you're asking, as court's already mentioned, but you're asking that agreement stay in effect per the mediated settlement agreement.
Yes, sir.
Okay. As far as dad, any communication with dad throughout the case?
And he did send letters, and I did receive those. The majority of those letters were to his son that was in a previous case,
okay.
Which his rights are terminated. So when I was receiving letters and such, I didn't have any directly to the girls. They were for his son. But I mean, once he does start receiving, or excuse me, sending letters, Avery, we typically we read them and then we give them to the therapist and let the therapist review them, just to ensure, they're mentally prepared, or what it may be, just to make sure that that's okay for them.
Okay. Any issue with allowing, since they do have an attorney, Ms. Zavala, to review some of those before they're turned over?
Oh, absolutely not. We would
And
encourage
and CASA also, if they would like to.
absolutely.
Okay. And have service plan stuff been sent to the jail?
Yes, they were.
Okay. So to your knowledge, now those were sent, to your knowledge, Mr. Solis received them.
Yes, he did. He actually, one had included a signature page to be returned, and that was returned.
Okay. And I believe he mentioned, but had he worked any services while he's been in jail?
He did indicate that some of the parenting and stuff in there. But I mean, a lot of services are very limited based upon the incarceration and such.
Okay. Is there anything that you need to, that the court needs to know, or that you would like to update the court on, going forward?
Going forward, no. They're just in regards to the dad. I mean, he has more charges other than the possession that he is in jail for, when including injury to a child. So
I'm not in prison for that right now, ma'am. I'm not in prison for that. That's an old sentence, ma'am.
You're not on the stand, sir. You need to be quiet. Thank you.
And so as far as reviewing, when you review the offender search and stuff like that, it is listed on there, as far as his sentence date and his time that he received for that sentencing. So, that is some of our concern with that as well.
Okay. All right. I'll pass the witness, Your Honor.
I'm gonna pretty much call this a review unless there's something that's just outstanding. You can wave at me.
There is, Your Honor. I would like to call Dad to the stand real quick. I have something I need to take up with him.
Okay. Is everyone okay with Ms. Cantrell's testimony? Nothing. Okay. Okay. So, Mr. Solis, I need you to raise your right hand. Okay. Do you solemnly swear or affirm the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, Mr. Trell.
Thank you, Your Honor. Mr. Solis, would you state your whole name for the record, please?
Neil Solis Sr.
Okay. And now, previously, you had been adjudicated as the dad on Annalisa, correct?
What do you mean What do you mean by that?
It means basically that you've been named the legal father.
Yeah, I mean, I'm biological father. Yes.
No,
Okay.
did you ever take a DNA test?
Yes. And as soon as this case was open, you made me take one.
In Your Honor, that's what I'm fixing to clear up here. So on Annalisa, Your Honor, back in I believe it was 2021. Let me see. 2021, there was a AG's case filed. Mr. Solis had signed a AOP, an affidavit of paternity, as far as Annalisa. The AG's office had paternity testing done as to his son, who was in the prior case, and as to Alyssa. Looking back, I have not seen per that paternity testing that he was ever adjudicated to Alyssa. So that is what I'm supposed to clear up, to see if he wants to be legally adjudicated based on the paternity test that was filed in this case back in on August 10th of 2022. There was a paternity test that showed that he was the biological father, and could we adjudicate him today?
I'm going to assume, sir, that you want us to go ahead and name you the legal father then.
I mean, the DNA test came back that those are my girls. So I mean, biologic, those are my girls, right? So that's what he's saying, right? I mean,
Yes, sir. He just wants to make sure that you're
okay. I mean, yeah. I mean, I'm yeah.
okay. Then that will happen.
Thank you, Judge. That's all I have, Your Honor.
Okay. And which child is that?
That's on Alyssa.
Okay, so on the record, Alyssa will be adjudicated today, and Mr. Fleece will be named the adjudicated father.
Thank you, Your Honor.
Excuse me. I'm a little lost about this system. So you mean to tell me that this whole 12 months that this case has been open, you're just barely going through this process right now? Is that what I'm hearing from you, Mr. Trout? That you're just barely doing this process right now?
He basically is taking the document that said you're the father and just making it an actual adjudicated document. It's been there, and he's just cleaning up the process.
Okay. I mean, it just seems, abnormal that it would take 12 months to clear up this cleanup that you guys are doing. That's just amazing to me.
Okay. Any other questions?
No further questions, Your Honor.
Okay. Do any of the attorneys have any questions for the gentleman?
No.
The only thing that I'm going to ask of St. Francis is that because Mr. Solis has made the statements he's made about the social worker and stuff, I would ask that you personally contact that prison and talk to that caseworker, social worker, and see what all they have and what they provide. So that, and if you can, get something in writing, cover all the bases, see what they've got there, and whatever they don't have, if you would send a packet to him as soon as humanly possible, so that he's given the opportunity to work these services. Can you do that for me, Ms. Control?
Yes, ma'am. I will assist Avery once she returns from leave, and we'll work on that together.
Okay.
Your Honor, that packet was supposed to be mailed to me 2 months ago, I believe, and I sent back word to both parties, the caseworker and my attorney, both of them, saying that I never got the packet because when Joe Jackson wrote me, he specifically said, if you don't get the packet, let me know, and we'll get it resent to you. So I'm been aware that this packet is supposed to be coming my way, but it's been 2 months and I haven't heard anything, ma'am.
Well, it will be in the mail to you by the 1st of next week. Right, Ms. Cantrell?
I will make it happen.
Just get him a basic packet and send it, and you can tailor make it down the road. But he can get
definitely. Yes, ma'am. We have parenting packets that I will definitely start with.
Okay.
So that'll give him something to do in the meantime while we find out, like you said, the services that they can offer and what other packets we can send during that.
Good. Apparently they have a social worker, so that at least some of the prisons don't, so at least you have somebody to contact.
Yeah, I appreciate you.
Thank you. Anything else today? I believe that you all got a message from Rachel inside the extension of having a hearing date on February the 11th at 9 a.m. and then setting the final for April the 8th at 9 a.m. Of course, that's subject to any other hearings that may be necessary. Do those dates work for everyone?
Yes, ma'am.
Okay. All right. So we will have a substituted attorney by as soon as Judge Baker gets back and can sign that order. And let me remind you, I don't think I gave you the statutory warning, sir. I'm required by law to tell you that you are to work your services to the best of your ability. They're going to send you the packets. They're going to contact the social worker. You now are going to have a little bit more hoop to jump through. So you got to work those services as you've requested. If you don't, that's one of the grounds that can be used against you to terminate your parental rights. Do you understand that?
Yes, ma'am.
Okay. All right. Anything else today?
Only thing,
No,
Your Honor, I know we have the review dates and set. The new dismissal date based on the extension would be April the 21st, 2025.
Okay. Thank you. Okay. Anything else?
No, that'd be it.
Okay. Thank you. We'll
Thank you,
go
ma'am.
off the we'll go off the
You too.
record.
Thank you.
Oh, that one took a twist. So